from a legal standpoint, what are your feelings about that judgment?
Well, looking at the judgment and how this case has been right from the start and to the very few moments before it ended, one could have seen the direction it will go. Why? My reason is that, the prosecution has stated the side of this case. The onus was upon the defendant, Nnamdi Kanu in this case, to open his defense. He refused to do that. That, for me, yes, if you refuse, it's just like you're saying that you're hanging your own case on the prosecution. Whatever they have said, I don't have anything to say.
So technically, that's what he did.
Yes, technically, that's what he did. So that means that the court ruled on the strength of what the prosecution presented.
I see.
Yes, Section 36 allows you right of fair hearing, but you can, it's not in perpetuity. The court, you will see that over time, the court was saying that open your defense. Open your defense. When he failed to do that, the prosecution had no choice and the court had no choice than to foreclose his right to defend the suit, which means that he does not have a defense.
Do you think he was advised by his lawyers to do that? Or he took it upon himself?
Yeah, I want to think that he took it upon himself because at the point, he had lawyers at the time. I think the analyst, Kanu Agabi, yes, was one of his lawyers. And at that point, they withdrew their representation, and he said that he wanted to defend himself in that suit. So it was his decision.
Did he get rid of the lawyers, or did they leave him?
Well, from what he said, from what is in the public, he said, the lawyers said he told the court that he wanted to represent himself. So the lawyers had to withdraw.
So that was one of the things that a lot of people have expressed all kinds of sentiments. But I want you to explain to us the sacrosanct nature of the law courts. How your other colleagues that I know have told me that when a case is before a judge, it's the facts that he looks at.
Very well.
The facts, the political things. In fact, I'm told that if you commit an offense in front of a judge, by the time he's looking at the case, he might jolly well does not decide that what he saw was what it was. He will always look at the facts.
Yeah.
So, in this particular case, there's no point asking you to file because he didn't file a defense.
Yeah.
Wrong strategy. And he was always attacking the judge. Why was that? Was it to intimidate the judge or what?
Well, I want, from his disposition in court, there's what we call fashe in Korea. That's contempt in the face of the court. And you will see that his disposition at times very violent outbursts against the court, against lawyers in court. Ordinarily, if you were an ordinary citizen, even a lawyer would not do that. I've seen instances that a lawyer is addressing the court and is probably agitated and backs the court, and the court takes offense and says, no, you cannot do that. Their ethics are, like I said, the legal profession is highly conservative.
Do the ethics apply to the accused?
Yes, it does.
I'm just asking.
Yes, it applies. Everybody who is in the face of the court, you will see that even when you are going into the courtroom, you are asked to remove your cap if you are having one on. So it shows to you the sanctity of the courtroom. That's why you will see that accused or defendants are not handcuffed into the courtroom except they are violent. And you will see that all these mannerisms shows that you must respect the court. You must respect the law. And his agitations were a little bit untoward, and he shouldn't have been tolerated.
So, what's the maximum sentence for the was death? But the judge said that because of his human disposition, he made it life. Why did he have to explain that? Isn't he supposed to follow? I'm just asking.
Yes, when the court is giving a decision, it is within the right of the court to explain the reasons for his decision. And it's just at the point that you have to give the maximum sentence, it's discretionary to say, the law permits the court to exercise its discretion to the fullest and of course reduce it. In this instance, the maximum sentence is death by hanging, or
for the charges against
yes, it's treason, for the charges against it. But the court said, okay, I'm giving you life imprisonment. So the court had to explain the reason why he did not go for the maximum, which is death. but life imprisonment. So I think it is in order for the court to do that.
I was quite fearful when the judgment was being read, and the judge was reading and talking about what. I was quite fearful that the judge might decide to go the whole hog. So the judge, in a sense, did him a favor.
Yes, well, as it stands, yes.
Okay, so the what would he be saying in his appeal? I assume that he'd like to go to the appeal court. Can he go to the appeal court by himself, or he would definitely need a lawyer?
Well, I would believe that he needs a lawyer to file his appeal. Reason is that when you are filing an appeal, you need to prepare your brief, and even lawyers need to know their onions to be able to mash out the necessary arguments and put up the necessary documentation to appeal. And an individual who doesn't have a law degree, it might be difficult. Of course, he might engage consultants, lawyers to prepare the brief, and if he decides to argue that case himself, when he gets to that point. But it's strongly advised that he uses the services of his lawyers.
Let's say that you had the brief. Do you think there are any grounds on which the appeal can be filed? If you go to the appeal court, wouldn't the appeal court be saying that, but you didn't file a defense? Do you understand?
Yes, that's why it was, for me, it's my opinion, it was a tactical error not to open his defense. If you have an issue that you are objecting, that you're saying that the laws for which you have been tried are not sustainable, or the charge is not sustainable, you have a right of appeal. Bring in a preliminary objection. If the court overrules it, and of course it's sacrosanct in law that the issue of jurisdiction can be raised at any point. You can go to the court of appeal to object and say, the trial court had no jurisdiction. You were tried for a charge that is not existent. Go to the court of appeal, but you have to open your defense, because it's a tactical error.
Yes,
you were given several opportunities to do that. So as it stands, his chances are
because he kept predicating part of his case, he kept on the fact that he was kidnapped and brought to Nigeria, and that he was said to have, he said in his own thinking that he committed, that again, it's funny, said he committed the offense in the UK and that it shouldn't be tried in the Nigerian court. Does that hold water?
Well, the truth of it is that he was tried in Nigeria. Mm-hmm. The actions for if whatever he carried out was in the UK, but the effect was in Nigeria. And you will see, I've gone through the judgments, about 144 pages, and the court took time to detail these instances of the sit at home, people who died as a result of this order. There was a time that he requested for 100 heads, 10 heads escape, so many
requested for 10 heads.
Yes, in the job where he was saying that I need 20, I think it was 2021. It was even dated, I think it was May or October from the judgment. The court took time to state all this, and I think from the judgment, the prosecution presented witnesses who spoke about people who were direct victims of these proclamations that he did. Those who went out during the sit at home, who were burnt to death, fathers who lost children who lost fathers, wives who lost husbands. All these things were stated in court. So it would have been better if he had presented his own defense to counteract that. No, okay, there are so many ways that you could put up your defense.
Well, what is sad is that most of the people who died, directly or indirectly, are also his people. I mean that.
Yes, and the court even stated that in its ruling, in its judgment, saying that that's why he said people who were directly affected are the Igbos. The people who are his people. That the sit at home was within his base, not outside that place, and so it means that people were directly affected. If you say that you were just that it was just a buffer, it was just a talk on the street, or you were just talking, but it had direct effects on people from your area who you were agitating for.